stated it cost all taxpayers, that was a true statement. Because in our bill, in our state budget bills, the entire state of Missouri had to assist in financing the recovery. So that was the taxpayers in the metropolitan areas. And also, one last thing is, there's always a debate on prevailing wage, union rates and non-union rates. Prevailing wage is set by each county. It only takes 1 hour to set the wage rate in that county for that classification of work. And the whole idea of prevailing wage is not due to some of the racist ideas that was brought forth by the Lieutenant Governor, but to give the local contractor an opportunity to compete. If you look in Joplin and that tragedy tornado, there was a demolition contractor from Georgia that came up, and the Attorney General convicted of him of not paying the proper wage rates. A lot of those local contractors in that area that were non-union were highly upset that they weren't able to compete, and a contractor from Georgia was able to underbid them. Once those wage rates of trying to get those wage rates from that contractor was sent back to Georgia and convicted of not paying the local wage rates. So,
Can I see the hands of those who are here to testify for this bill? Those against? Okay, we're going to have to move on, gentlemen. I'm sorry.
Mr. Chairman, and one last thing on it. When you're talking about labor cost is only about 25% of the project. Materials is what costs the larger portion. So if you have higher strength in contract or concrete, more rebar needed, more things to withstand a tornado, that's going to cost more money as well. So you can't bear the burden of increased cost on labor when it's a minority price tag of the project.
Thank you, Senator. Appreciate it. Mr. Jim Fall, I have listed here.
My name is Jim Fall. I'm here. I'm an attorney for the AFL-CIO. I'm also here today on behalf of the St. Louis Building and Construction Trades. Just wanted to briefly reiterate not only the things that Mr. Lewis as well as Senator Green stated, but emphasize the point Senator Green mentioned Katrina. One of the reasons that was put forward when President Bush repealed his executive order and reinstated prevailing wage was an issue of migrant workforces coming in, displacing those that were there, creating a problem not only of displacing local workforce, but also of background checks, making sure the quality work was done. Further then, again, just to reiterate the point that Senator Green, I think, made very well, is the MHDCA made this decision. They're the ones that were held to with the authority to make the decision not to allow prevailing wages on these kind of projects. I think they're the body best able to understand the reason, the rationale, and to decide if that decision is a good one for the use of the money that they're entrusted with or not, rather than this body. Obviously, you know, every election, every new seats change, but I think that the authority that the MHDCA has been granted should be, they should be allowed to use as they see fit as trustees of the state's money.
Thank you, sir. Mr. Craighead.
Morning, Mr. Chair, honorable members of the committee. Richard Craig, United Steelworkers District 11, just the one on record as being opposed to this bill. No other testimony given at this time.
Thank you, sir. Others that testify against?
Mr. Chairman, members of the committee, you're going to like me a lot better this time than last time. I think former Senator Green stole my testimony, so I'd just like to reiterate several of the points that he made. Again, my name is Adam McBride. I'm here on behalf of the Laborers International Union North America. We represent roughly 14,000 construction craft laborers here in the state of Missouri. We just like to go on rates like Groundhog Day. You know, we just like to go on record in opposition to the sponsors bill.
Thank you very much.
Mr. Chairman and members of the committee, my name is Jim Farrell, representing the Carpenters District Council, Greater St. Louis and vicinity. And we want to go on record in opposition to this bill. I passed out a one-page brochure that talks about something that I think is very important, particularly in these times of disasters and the devastation to these types of communities, because many of the organizations that are here behind me, including the Carpenters Council, are integral parts of these communities. And the wages that those individuals are able to earn really goes back into the community many-fold, not only through their participation in income and the things that they purchase, but the organizations themselves often contribute to the local communities, the not-for-profits, the organizations that are very important in these communities that provide all types of services. And this brochure identifies that. In fact, during this time of disaster, the Carpenters Council donated $100,000 to the disaster effort that was not from their district council. It was from the members and individual contributions and donations that they made at that time. So it just goes to the point that it goes beyond just this issue of the wages. They are very important parts of the community, and that's my testimony for today.
Thank you, sir. Are there others here to testify in opposition?
Thank you, Mr. Chairman, members of the committee. My name is Bruce W. Holt. I'm a registered lobbyist with the International Union of Painters and Allied Trades, representing all of our members active and inactive in the state of Missouri. I'll keep it very brief. I know you're pressed for time. I just want to say I empathize greatly with the people from your home district. In 1972, my parents lost their home and everything, and the only memories I have of my childhood are in my mind, because there's nothing else there. It was all washed away. So I do empathize with them, but I think that you go back to the history of what happened to Katrina, you'll see it here. Thank you very much.
Representative Kelly.
I'd like to inquire briefly of that,
Go
witness
ahead.
if possible, and it will be very brief. Gentlemen, I'm just curious, if your family had rebuilt their home, which I'm assuming they did, and the state had rebuilt the identical home next to it, do you believe that your parents' costs would have been less?
I think it would probably been about,
You believe that it would have been the exact same? They would have paid prevailing wage to the people that rebuilt their
that was in
home?
1972. The law wasn't in place at that time. And the house that I grew up in was built in
If we were building it today in Joplin, if I was
Today
building
in
a home
Joplin.
and the state was building a home, would the cost be the same?
I would have to look at what you're doing with it. I don't know. You have to tell me. Fabric, material, everything.
Identical. Everything's identical, only I'm hiring my local contractor that normally does the jobs in Joplin versus the ones that are different. I think what this bill does is shows we're overinflating the cost of a home. And I wish that people would come to realize this isn't about raising, the wages of people. It's not about changing the wages. It's simply about increasing costs on a project that if I was building an identical home next to it, would cost less. Same exact home, and those employees are the same exact employees.
If they're building it under the current law with prevailing wage, it'd be exactly the same cost.
But I'm not, as an individual, paying prevailing wage to those employees. I'm hiring that same contractor at the wage he would normally make working in Joplin. If I went to Joplin to hire that contractor, I am not overinflating the wage by creating a government standard. I've heard your association state you wish government would just get out of the business. We're trying. Let's not require the government to create the standards. Let's let the market do that. Thank you, gentlemen.
Next witness, please.
Mr. Chairman, my name is Scott Ramshaw. I'm with the Plumbers and Pipe Fitters out of St. Louis. I'm the registered lobbyist. I just want to bring attention to the committee that the federal prevailing wage that they are using under the Davis Baking does have a residential rate, where the Missouri rate is a construction rate. So for residential rate, it is lower in the state. That survey's done probably just depends on when the government can get around to it. I know they just did one, I think it was 2 years ago possibly on the residential, it could be 2 to 3, I'm not sure. But one of the things that when you talk about the tax credit, individuals going for that, developers and companies that do get into that market, one of the things that they're not doing that project for free. Those developers and individuals that are involved with tax credits, nobody knows that market better than those developers that are doing those projects, and they're in it to make money. So as you talk about the percentages of 4% or 9% on money, I would hope that nobody thinks a construction worker is a 4% person or a 9% person, because most contractors are looking at a profit anywhere from 9% to 15 or 20%, whatever they can make profit on each construction project. So I am concerned that every time we hear a bill in this committee, it's always about the wage of the worker. So it keeps reverting back to that. I don't know if that's intentional, I don't think so, but it always comes down to the worker's rate. So whether it's non-union or union, and one of the things about tax credit money, I do not believe all the projects that come out of the housing tax credits, I cannot believe all those projects are done by union contractors. So I just don't see that. So that's my testimony. If there's any questions, I'd be more than happy to answer them.
Thank you, sir. Are there others to testify?
Thank you.
Good morning, Mr. Chairman, representatives. I'm David Clarish today, appearing against House Bill 1144 on behalf of the Mechanical Contractors Association of the Eastern District and Kansas City.
Thank you, sir.
Mr. Chairman, members of the committee, I'm Ken Mendes. I'm the registered lobbyist for the Sheet Metal and Air Railroad Transportation Union. I'd like to go on record in opposition.
Thank you, sir. Are there those here who wish to testify for informational purposes? None appearing, this will close the hearing on House Bill 1144. Representative Barr and Mr. Audience.
He's right outside, Mr. Chairman.
We'll now hear the
Thank you, Mr. Chair, members of the committee. For the record, I am Representative Kirk Barr from District 102 in St. Charles County, and I am presenting House Bill 1642. The purpose of this bill is to give our small business owners in the state of Missouri a little bit more certainty, a little bit more clarity. This is very much a pro-business, pro-small business piece of legislation. What it does, it has two major functions. The first major function is it requires the Department of Labor to be more clear as to who should be and who should not be independent contractors. And then, it talks about, there's three different things that says that we should do to go ahead and recognize somebody as an independent contractor. The first one saying, if you're an LLC or if you're licensed by appropriate local authorities and provide services for multiple customers, or if you're a lawyer, then you should be deemed as an independent contractor. The reason I threw that third part in, aside from my love for lawyers, is that one of my businesses in my district, they had an audit by the Department of Labor, and the Department of Labor tried to say that their legal counsel should have been hired as an employee. The other thing that this bill does is it says that if the IRS gives 530 injunctive relief, which basically says you've been operating under legal counsel, you've been operating consistently, and you've been paying people 1099s, you've been paying these people consistently as independent contractors, we're going to go ahead and say whether or not they should or shouldn't be based on the 20-point test that both our state Department of Labor uses and the federal IRS use. We're going to go ahead and say you're good, you may continue to operate paying these people as independent contractors. That's what the 530 injunctive relief is. And so the second part says, if the federal IRS gives 530 injunctive relief, then our state will recognize that as well. So the whole purpose of this bill is to require the Department of Labor to notify, if they make changes, notify the public, notify the business community, if they make changes of how they're going to determine whether or not somebody is an independent contractor, that they tell the business community, so that a business owner who's operating correctly one day doesn't find out that they've been audited and, oh, oops, no, we kind of changed our mind, we're going to do things a little different, now you're wrong. The other last little bit of this bill, if during the appeal process, a business is appealing the ruling saying that they're paying independent contractors should have been, these people should have been classified as employees, that during that appeal process, the fines and penalties are, the bill uses the word told. Basically, they're not being penalized while they're using their ability to appeal. So those are the major functions of the bill. The problem is that our current Department of Labor takes some liberties with the 20-point factor test on determining who should and who shouldn't be independent contractors, and we need to give a little guidance to our Department of Labor, and we need to give clarity to our small business owners as to what Missouri defines as an independent contractor and what Missouri defines as an employee.
We have questions? Representative Frame. Go ahead.
Thank you, Mr. Chairman. So I read your bill last night. It was a little late getting into yours, but was trying to follow through and got lost along the way, if you don't mind. So right now, you mentioned we do have a 20-point questions that to help us determine is a employee actually an independent contractor, correct? I'm sorry, other way around. Is an independent contractor an employee?
That's the intent of those 20 points, yes.
Okay, and so what's wrong with that?
Nothing is wrong with that if our Department of Labor followed it.
They don't follow?
Well, they do, but it's not fully binding. They use a little discretion.
Okay,
And
how so?
Okay, I'll use the example, and my constituent is here with me to testify in a few minutes. He has a business that he employs, doesn't employ, he hires a lot of independent contractors.
Mm-hmm. Oops.
However, and he's operating perfectly legally, perfectly fine. He got an audit 3 years ago, that's still ongoing. But the Department of Labor, when they first started doing this audit, I had them come to my office and discuss this case because of the 20 points, he meets about 15 of them. Legitimate. These are.
You're calling an audit, but I'm sorry, you're calling an audit. Is it an investigation you're talking about?
Yes.
Okay. All right. Good.
So he meets a preponderance of the 20 points. He meets. No, you're good. These should be independent contractors. Okay. And at that, it should be done. There are a few that are questionable, and there are a few that, there's about 2 or 3 points that you can say, no, these 3 things you kind of fail on the test, but the standard is a preponderance. So of 20, is it more independent, more employee? And the preponderance for him is very much so independent contractor. But the Department of Labor said, well, yeah, but we kind of look at, if you're an LLC, we pretty much assume you're good. They don't bother telling anybody that. And so some of his trainers who had an LLC, they didn't put on the list of these people should be employees, but a lot of his trainers are stay-at-home moms, college guys who are doing personal training while going through college, and they haven't bothered to set up an LLC. And so our Department of Labor is saying, no, these trainers should be employees. And oh, by the way, your lawyer should be an employee too. And some people use gave reimbursements too, they should be employees. And some guys who live and work over in Illinois, they should be Missouri employees.
Okay. I can imagine folks didn't bother to set up an LLC. I wonder if there aren't many employees throughout Missouri who think they're employees, but they're being reported as independent contractors.
Well, if you get a 1099 at the end of the year, you're an independent contractor. If you get a W-2, you're an employee. If you don't know the difference, then you should call somebody.
Good point there. So, and that works for the contractor as well too, right? The employer.
Yes.
We don't require a test when you create an LLC, for example, right? There's no test given of do you understand business law?
No, it's $50 and a form with the Secretary of State's office.
Good. So the fact that these folks don't know what the current law is isn't surprising. Independent contractors versus employees.
Well, the problem isn't what is the law. The problem is what will the department define the law to be. So you have a business who has a business model who goes and says, am I doing everything right? Gets legal counsel, they've been told, yes, you're doing everything right, and then they get an investigation, an audit, and then the department says, well, yeah, you know, you meet the preponderance of these 20 points, but these people weren't LLC, so we're just going to say you're guilty.
Okay, how often do you think that happens?
I have a constituent who it happened to, so it does
That
happen.
doesn't come close to answer my question. Is it a common thing that we have that quite a bit? It happens all the time, or is that
You
kind
know,
of a rarity?
I haven't asked the department how many times they screw up their audits, but I do know that I've talked to a number of business owners, and they like this idea of having that certainty, that ability to know, am I doing things right or am I doing things wrong? Not, do I have to wait for the investigation to tell me, oh, by the way, you're guilty, when they thought they were following the law.
Okay. The 20-point question sheet you're talking about, sounds like that's kind of a stumbling block for you. You've nailed down to 3 points, am I correct?
No, sir.
No?
No, I support the 20-point questionnaire,
Okay, all right.
and that's what our state uses, and that's what the IRS uses. But what my bill is designed to do is to limit the Department of Labor's discretion on how they view those 20 points a little bit, and also to give the business owners a little bit more knowledge as to what is and isn't going to be expected of them. So when they go into setting up their business, they know beforehand, this person I can have as an employee, or this person I can have as an independent contractor. Not, I'm paying this person as an independent contractor. 3 years later, I get a knock on the door saying, no, these should be employees. And oh, by the way, now you have thousands of dollars in fines because you did it wrong.
Got it.
And
I got a couple questions I want to ask. I'm trying to get microwave the answer we can. So if I indeed seek an LLC, go file the paperwork with the Secretary of State's office, become an LLC, I am then an independent contractor by definition of your legislation, correct? Even though,
you'd be a business owner.
well, no doubt, but would I be an independent contractor
Well, it depends
as long
on-
as I had the LLC behind my name?
Well, it depends on what your business was. I mean, would you say every store owner is an independent contractor, or are they contracting with somebody? You have to be in contract with somebody to be an independent contractor.
If I go to work for as an employee, although the employer is actually giving me direction, telling me what time to be there, telling me what time I can leave, giving me direction on what I'm going to do while I'm there, if I have the LLC behind my name, I can be classified as an independent contractor.
My bill does not say a person who should be an employee but has an LLC is now going to be classified as an independent contractor. My bill does
What would
not
stop
say
an
that.
employer from doing that? Because here's my problem with the bill, is I can see a lot of employers preparing LLCs, that all the employee has to do is walk up there and sign it. He is now an LLC. Wait, that's great, I'm a business owner at this point now, but you're exempt from all the protections of being an employee. That's my problem with legislation.
I see your concern. My bill does not allow for that, and if you want to discuss later how we could perhaps tweak language to make sure it does not allow for that, I'm open to a suggestion like that, but that's not going to be a
That's
problem.
kind of what I read when I was reading it last night. Like I said, I got to your bill late, I have other ones as well, but when I read through it, I could see someone doing exactly that. An employer setting up a big stack of papers, calling all the employees in, doing nothing differently whatsoever during the course of a normal business day, but now those folks are protected by the LLC. It sure looks like so. Maybe we should talk.
We can talk afterwards.
Thanks so much. Thank you, Mr. Chairman.
Representative May, briefly, please.
Hi, how are you?
Doing well.
Listen, I just got a quick question. So if you look at, on page 2 of your bill, what you're saying that is you're asking for the department to give me a classification up front, whether I'm a limit, if they're, the classification of the employees, you're asking them in an opinion letter, are these independent contractors, or would they be considered employees?
Yes.
So so as me as a business person, I'm inquiring up front to avoid the audit later.
Exactly. The whole purpose is to provide certainty for our business owners.
Okay, so if I know up front, then I'll know how to proceed.
Exactly.
Okay, thank you.
Did you have any witnesses to testify for you?
I do have one witness.
Bring them forward, please. I would remind all witnesses to please fill out forms and turn them in.
Chad Rumley, president of the company who's talking about Dynamic Fitness. I would not want to focus on the issues that my company has dealt with this. A couple things I looked at. 2008, the Illinois legislature passed a similar act, Worker Classification Act. We do business in Illinois as well. The uncertainty